speaker today is a graduate of Harvard Law School. She is an associate in the Los Angeles office of the law firm Foley and Lardner, where her practice focuses on business litigation, e-discovery, and white-collar criminal defense. She has written articles that have been published in the Bloomberg Business News and Analysis, California Daily Journal, and Legal Technology News. She founded the blog www.hamiltime.com, which is just a tremendous, yeah, we got some fans in the audience. And it provides legal history, news, book reviews, and pop culture analysis related to Alexander Hamilton. It's very diverse and always well written and researched. Her presentations on Hamilton law cases were given this past year at Federal Hall, which is just one block west of here. Many of you walked by there. And at Hamilton's home at Hamilton Grange in Upper Manhattan, which included the 1804 People versus Croswell case, which led the way to establish the use of truth as a defense for libel. Back then, if you said something negative about someone, they could sue you. It didn't matter if it was true, so that was quite fascinating to hear Pooja's talk on that. And also interesting was the Time to Peter Zenger trial. It dealt with free speech back in like 1735 time frame, something like that. And interesting, that was held in City Hall, which is on the location of today's Federal Hall. So the interesting tie-ins is it was just well received. Tomorrow, our speaker will begin talking about another famous law case that happened in 1800 called the Manhattan Well Mystery, where Alexander Hamilton and Aaron Burr were the defense co-counsel, which is very fascinating. That was in 1800. So you understand the time, just within a year he was Vice President of the United States. And that will be held at Morris Jamal Mansion in Upper Manhattan. So now, ladies and gentlemen, the talk entitled A Bar Fight That Changed America, Alexander Hamilton, the Trespass Act, and the case of Rutgers v. Waddington. Our speaker, Pooja Nair.
New York, at the close of the Revolution, was a city that had been battered and bruised by the long occupation of British forces. The patriot civilians who had resided in New York City had risked everything to support the cause, and many had made deep personal sacrifices, including abandoning their property and fleeing to escape British forces. Patriot civilians had been forced to flee and abandon their property, and loyalists who remained behind in the city took over these businesses, homes, and shops. As the war came to an end and victory became inevitable, the Patriots started to reclaim the city, and the state legislature resumed full operations. Years of hardship and occupation in New York resulted in a deep spirit of vindictiveness by the Patriot civilians against the loyalists who had stayed behind and profited during the war. And into this mix came 27-year-old Alexander Hamilton, who had been actively involved in the early Patriot movement and had served as Washington's aide-de-camp until 1781. Hamilton returned to New York after his war service and began life as a member of the small New York bar. As with all legal dramas, the story I'm telling you today about Rutgers versus Waddington is a story with many layers. It is the story of a brewery and the two owners who occupied it in a tumultuous decade. It is the story of how New York City as a whole faced the crucial turning point and decided how they would treat the people who were defeated during the Revolutionary War. And it is also a story of a young lawyer named Alexander Hamilton and the way that he began to articulate principles that would become the founding principles of American law that we still benefit from and rely on today. I want to first set the stage for you and tell you how we arrived at the Rutgers versus Waddington case. So in the summer of 1776, the British began to descend on New York, and they took over. General Howe takes over most of the city in the summer of 1776. Many inhabitants who are supporters of the Patriots, even people who have been in New York for a long period of time, flee that summer of 1776. And at the close of the war, when people slowly began to return to their homes and the state legislature resumed what it was doing, the state legislature began to pass anti-loyalist measures that would directly punish people who remained loyal to the British for their participation during the war. These acts included the Forfeitures Act, an Act of Attainder in 1779, and the Citation Act of 1782. Now note that these acts were generally, while the Patriots had resumed and were about to emerge victorious, but before they had actually defeated the British. And they took away, they stripped the property of people who had supported the Tories, and they also punished them as spies. It was kind of wartime legislation. And New York was one of the most active state legislatures in propounding these kind of anti-loyalist acts, partially because the people of New York had suffered so much during the war. In August 1783, Hamilton noted in a letter to James Duane that some late indictments in our state have given great alarm here. Many who have all along talked of staying now talk of going. We have already lost too large a number of valuable citizens. So Hamilton's opinion, as expressed in this letter, was that the fleeing of loyalist citizens in New York was dangerous to New York for two reasons. One, first and foremost, he believed that the Tory citizens should be incorporated back into the New York economy, because this would be important for New York to be able to grow and to regain its economic status after the war. So when he speaks of valuable citizens, he means both that the citizens are actually valuable and that they contributed a lot of value to the New York economy, and that he believed that these were people that were worth keeping in New York City. Now, a lot of the anti-loyalist acts that were passed around this time, the broadest was the Trespass Act. This was an act that was passed in March of 1783. And it was titled an act for granting a more effectual relief in cases of certain trespasses. So what this act did is it created a right of action, so that if I had a piece of property in New York and I had abandoned that piece of property, and when the British had taken over that particular piece of property, my home or my business, and they charged rent to the loyalists who began to reside in that property after I did, I could then sue that person for back rent and had a cause of action against them for the crime of occupying, for the act of occupying my house during the war. And while the other measures that I discussed briefly earlier had specifically targeted loyalists, this one was the broadest in scope and created the broadest cause of action. Now, a few months after the Treaty of Paris, in September of 1783, a few months after the Trespass Act was passed, the Treaty of Paris was signed in September 3rd, 1783. And this formally ended the American Revolution. Adams, Franklin, and Jay negotiated it. And Articles 5 and 6 of the Treaty of Paris specifically dealt with the treatment of loyalist citizens at the end of the war. So Article 5 asked Congress to recommend that state legislatures provide restitution for the estates, rights, and properties that have been confiscated by the states and which belong to British subjects. And Article 6 specifically dealt with the topic of future confiscations. Article 6 stated that there shall be no future confiscations made, nor any prosecutions commenced against any person or persons by reason of the part which he or they may have taken in the present war, and that no person shall on that account suffer any future loss or damage, either in his person, liberty, or property, and that those who might be in confinement on such charges at the time of the ratification of the treaty in America shall be immediately set at liberty, and the prosecutions so commenced be discontinued. So the Trespass Act seems, if you think about it, to be an act, the prosecution of which would be in violation or be inconsistent with the principles of the Treaty of Paris, particularly Articles 5 and 6. A few months after the Trespass Act, a few months after the Treaty of Paris, in November of 1783, Washington makes his triumphant march into New York. The last British soldiers leave New York City, and on evacuation day, several thousand loyalist citizens go with them because they realize that there's rising anti-Tory sentiment in New York, and they're worried for their property and for their lives and for their livelihood if they choose to remain in New York. In January of 1784, Hamilton published his letters from Procyon, where they're letters to the citizens of New York, and he is expressing his disapproval of the anti-loyalist measures and warning his fellow citizens about the consequences of these anti-loyalist measures. Hamilton urged restraint from his fellow citizens, and Hamilton said, "Nothing is more common than for a free people, in times of heat and violence, to gratify momentary passions by letting into the government principles and precedents which afterwards prove fatal to themselves. Of this kind is the doctrine of disqualification, disenfranchisement, and banishment by acts of legislature. The dangerous consequences of this power are manifest. If the legislature can disenfranchise any number of citizens at pleasure by general descriptions, it may soon confine all the votes to a smaller number of partisans and establish an aristocracy or an oligarchy. If it may banish at discretion all those whom particular circumstances render obnoxious, without hearing or trial, no man can be safe, nor know when he may be the innocent victim of a prevailing faction. The name of liberty applied to such a government would be a mockery of common sense." So Hamilton made his opinions very clear in these letters. And then, and we'll go back to that, but in 1784, at the commencement of this Rutgers versus Waddington trial, Hamilton was 27 years old. He had just become a member of the bar in late 1782. And Hamilton had this, going for him, he was Washington's aide-de-camp and a military hero during the Revolution. So he was primed to enter New York as a pretty popular guy. And people were generally pretty angry and very, very suspicious when Hamilton became a strong voice against the Trespass Act and against these anti-loyalist measures. Hamilton believed that the Trespass Act was important for several different reasons. He really, really believed that this act of the New York State Legislature had multiple consequences for New York and for the nation. First, he was concerned with international legitimacy and how America would be perceived for allowing states to take these measures. He was also concerned about New York's economy and about New York society because he believed that that banishing or targeting the Tory faction in New York, which was pretty large, would ultimately hurt New York and cripple its economy. And he believed that this issue of allowing the state legislatures to undermine the Treaty of Paris that had been signed by the Confederation Congress would ultimately be bad for the nation. And he wanted to get a test case. That is, he wanted to have a case where he could directly take on the Trespass Act head-on. So in comes Rutgers versus Waddington. Now, in order to tell you the story of the case, in this particular instance, I have to tell you the story of the brewery, because this really is a bar fight. It's about a brewery. The brewery was located on Maiden Lane and Gold, so it's pretty close to here. It doesn't exist anymore, but it had been in New York for several decades, and it was owned by the Rutgers family. The Rutgers family, you may have heard of Rutgers University. It's a pretty long-standing family in New York society. And in 1776, Elizabeth Rutgers, who was a widow who supported the Patriots, Elizabeth Rutgers was the owner of this brewery. She flees in the summer of 1776 because General Howe is taking over New York. And as they're fleeing, they take whatever they can carry that's in the brewery, which is anything that they could physically take with them out of New York, they did. And in 1778, these two British merchants, Joshua Waddington and Elsa Pierpont, were permitted to occupy the property without paying rent. And this was under the authority of the Commissary General. And then in 1780, Waddington starts paying rent at the order of the British Commander-in-Chief. In 1783, in June of 1783, Waddington starts paying rent to Anthony Rutgers because at that time the British commander-in-chief is no longer in charge. Then, in November of 1783, a fire completely destroys the brewery. So this was on the verge of when they were about to re-hand over property. And the fire destroys the brewery, and there's nothing there. It's just an empty building with like remnants of a fire. And in December 1783, Waddington hands over the keys. Don't really mean much because there's nothing there anymore, to Rutgers. So you have two very different sides, and you can imagine where public sympathies might lie. On one hand, the plaintiff, Elizabeth Rutgers, was one of the first people bringing in a case under the Trespass Act. This family has a long history of supporting New York, of being prominent in New York society, and of sacrificing a lot for the revolution. And then, on the other hand, you have Joshua Waddington, who came to New York in 1776 as the British forces came in, and who owned a dry goods company and was generally a prosperous British merchant. Global writes, Rutgers to the man in the street became a melodrama because there, on one hand you have the aged patriot widow, and then on the other hand you have the scheming British merchant. Hamilton wrote in 1795 in a letter to Washington, he wrote that almost no one believed that they should even be taking this case. They thought that there was no argument and it was useless to attempt a defense. So who was prosecuting the case? And keep in mind here, I won't go into it in too much detail, but the New York bar around this time was tiny. If you think about the number of lawyers you probably know or know of in New York, imagine that in this time, I think in 1782, there was only around 50 lawyers that were registered in New York. And Egbert Benson was the Attorney General, and he was kind of a founding father of the New York bar. Also happened to be Mrs. Rutgers' nephew. Interestingly, when Hamilton decided that he wanted to take a test case, he approached Egbert Benson to be co-defense counsel with him. Benson refused because he was prosecuting the case on behalf of his aunt. John Lawrence, who I have not seen a picture of, was the person who did most of the work on the case. He drafted most of the briefs on the side of Elizabeth Rutgers. And then Robert Troup, who you know is Hamilton's friend and roommate at King's College, also happened to be friends with Aaron Burr, but was on the side of the plaintiffs here. So you can kind of see that with regard to this issue, a lot of people who you might not think as aligned politically had different opinions as to whether these anti-loyalist measures were good for New York and were justified or not. And then on the defense counsel, you also have an unlikely team of people who you wouldn't expect to be on the same side. You have Morgan Lewis, Alexander Hamilton, and Brock Pulse Livingston. Hamilton was the one here who did most of the heavy lifting. So it was Hamilton and John Lawrence, the two youngest people on both sides of the cases, that wrote the majority of the briefs. And the court that this case was heard in was the New York City Mayor's Court. This court was run by the mayor and the city recorder, who was something like a vice mayor, and then the alderman who sat on the city council. And Thomas Ivers, actually, who was one of the aldermen sitting in this case, had a pending active case under the Trespass Act that he was trying to prosecute, and Hamilton defended a few months after this. So the court had just reopened in February 10th of 1784, and on February 24th, 1784 was the first day it was open for business, and this was one of the first orders of business that the court was concerned with. The court had several questions to think about here. They needed to consider whether whether they could take into account the fact that Waddington had permission and authority from the commander-in-chief of the British Army. Now, the text of the Trespass Act specifically said that the military justification, or the fact that they had authority from the commander-in-chief, was not under the statute. Was not a reason to not have a cause of action. Was not a defense. So under the statute itself, you couldn't say that, oh, I was acting under the authority of the British commander-in-chief. The statute explicitly said that that was not an appropriate defense, which is why many people thought there was no possible defense under the statute. And so, additionally, the court had to consider whether the Treaty of Paris included implicit amnesty for Waddington's conduct. So Hamilton wrote several briefs, and he also wrote pleadings in the case. Briefs at that time were notes that Hamilton wrote that outlined his own argument, but weren't necessarily submitted to the court. And as Mariana mentioned, these Hamilton's briefs are stored at Hamilton College, and there's also a digital version, so you can really see what Hamilton was thinking through the course of his process. Hamilton really made three main arguments, three main reasons why he believed that the Trespass Act was invalid and that the court should find in favor of the defendant. And one of the underlying themes of all of Hamilton's arguments was the idea of international legitimacy. Hamilton believed that, and it's kind of apparent throughout his career, he believed that there was an important pressing need for the young country to really honor its international obligations, including its obligations under the Treaty of Paris. And he thought that this, like he believed that paying off debts was important, he believed that honoring obligations under the treaty was important, and was an important way to show allies what commitments the young country was willing to make. Hamilton also specifically argued under the laws of nations. You've seen upstairs the Grotius book. Hamilton made actual arguments that brought in international law. The law of nations was really something that had been popularized by political theorists in Europe. So Hugo Grotius in the 1600s had written a book on the laws of war and peace. And Emer de Vattel, a Swiss political theorist, had written in 1760 another book about the laws of war. Now the argument that Hamilton made under international law was that Waddington had acted under the authority of the British, who had conquered the city. And so this was a legitimate, just war under the laws of nation, right? So in a time of a just, legitimate war, people would expect that different forces would be occupying a particular territory. And when someone is occupying a territory, they have the right to tell people what to do. And people have the right to follow the orders of the people who are actively commanding that territory at that time. And essentially, whoever had possession of that territory was the conqueror under these laws of war. And it would be against the laws of nations to penalize countries for conduct that they had done during the war that was consistent with the operations required to conduct a war. Otherwise, the idea is that you'd have kind of chaos, because after a war, you'd be able to penalize everybody for conduct that they did during the war, and there'd really be no way to wage a war. Hamilton also raised some fundamental principles of judicial review. Judicial review is it's an interesting concept, right? It's the idea that a court can, it's an idea that when there's two conflicting sources of authority, the court will have to give precedence or to follow the highest authority. So in this case, the New York State Legislature made very, very clear that under the Trespass Act, this justification of following the military orders was not something that was a defense. But Congress had signed on the Treaty of Paris on behalf of the entire nation. And the Treaty of Paris required both countries to agree to these Articles 5 and 6, so that America would not be penalizing people because of their support of the British during the war. So Hamilton told the court that essentially it could not rule in a way that was inconsistent with the Treaty of Paris. they had to make it had to construe the Trespass Act in a way that was consistent with its international obligations. And if the court was to allow New York to make its own versions of if the court was to allow New York to ignore the provisions of the Treaty of Paris, then the court would be undermining, that single state would be allowed to undermine a treaty that was supposed to bind the entire nation. There's another theme that underlines Hamilton's argument. It's not clear in Hamilton's briefs as much as it is in the Phocion letters, but an important theme of all of Hamilton's goals related to these anti-Tory measures, was that penalizing a specific group of people, specifically the Loyalists here, but generally, he believed that targeting a specific group of people was dangerous for society, and that everyone should be treated equally under the law, because there was going to be a terrible effect if there was a precedent of people being able to penalize and target whatever group of people was unpopular at the time. He believed that maintaining this principle of equality and rule under the law was vital to preventing New York and preventing different parts of America from descending into mob rule, which was one of Hamilton's greatest fears. And he thought that creating specific rights for people to target Tories and have this cause of action would be contrary to equality under the law and would be damaging for New York and a damaging precedent to set in America. So what happened after this? This court, the New York City Mayor's Court, remember, was the mayor of New York, the city recorder, and aldermen. So they really cared what people thought. And they knew, based on the newspaper reports, based on the mob of people that had been surrounding during the arguments, they could tell where popular sentiment was. And they also knew that the state legislature was really counting on this group to uphold the Trespass Act. So the court was left in a difficult position, and it didn't really want to be in this position. Actually, the New York City Mayor's Court was one of the lower courts. They normally heard only smaller actions for smaller amounts between creditors and debtors. In this case, Mrs. Waddington had asked for back rent of $8,000, which was significantly high. And both parties could have removed the decision to a higher court, but instead they both chose to stay with the New York City, the New York City court, the New York City Mayor's Court. And so James Duane, who was a friend of Hamilton and who Hamilton had written about about his concerns of these anti-loyalist measures, Duane said Duane's decision is completely ambiguous. So if you read the decision, you can't really tell who wins and who loses. And it was designed like that. Duane found that the Treaty of Paris could not legally be violated by the state legislature. He said, no state in this union can alter or abridge in a single point the federal articles of the treaty. And he found that some of Waddington's actions in taking on the brewery and improving it and paying rent under the British Commander-in-Chief were justifiable under the laws of war. So they paid close attention to Hamilton's citations of the Law of Nations. But the court found that it's a weird split decision. The court found that the defendant was liable for the occupancy in the beginning of his time at the brewery that had been approved by the commissary-in-chief and not by the commander-in-chief. And so, but he was not liable, he could not be penalized for occupancy that he had, for the time that he had occupied the brewery under the authority of the commander-in-chief. So the damages that were actually awarded were $791, as opposed to $8,000 that had been requested. So it's clearly a small fraction. And writing about this, some scholars have called this a tortured line that Duane was drawing, trying to please everyone at the same time. But it's a decision that, at its core, supports the argument that Hamilton had made about judicial review. In other words, that a state legislature could not put forth an act that could not put forth an act that violates a federally signed treaty. So, as you might expect, there was major fallout after this decision. There was overwhelming support for Elizabeth Rutgers, and overwhelming condemnation of the New York City Mayor's Court as an institution, of James Duane, of Richard Varick, of Hamilton, of Livingston, and of Lewis for supporting cheating this poor widow out of the rent that she deserved for the brewery. And there were actually large public meetings that were scheduled throughout New York to discuss this litigation and to discuss what people were going to do in response. And there was a specific meeting in meeting houses, in Mrs. Vanderwater's meeting house, where the people gathered to kind of criticize the decision and decide what they were going to do next. And it was almost like mob mentality. People gathered to condemn the decision and to talk about what consequences it would have, what they could do about it now. And they characterized this as being, they characterized the decision of the case as something that was pregnant with the most mischievous consequences. And these groups were scary, especially for someone like James Duane and Richard Varick, who kind of relied on popular support and they served at the mercy of the state legislature. The state legislature actually was fairly angry because the legislature had specifically drafted the Trespass Act with the provisions to prevent military justification. And they found that the decision was subversive of all law and good order and leading directly to anarchy and confusion. And there was actually a vote in the state legislature that was held to remove James Duane and Richard Varick from their positions, but it failed very narrowly. So the period of time immediately after the decision, in the few months after it was held in the end of 1784, it was kind of massive fallout all over the city about this decision. And the people who had supported it and who had made it possible kind of hid in the shadows a little bit because they were scared of this fallout. And newspapers noted that the state legislature had really given like a rap of the knuckles to the Rutgers court because of their clear position that what the New York City Mayor's Court did was not legal. At this point, Mrs. Rutgers threatened to appeal the case to a higher court. And because Joshua Waddington and his counsel could see that the tides had really turned against them, they ended up doing what most cases end up doing today, settling out of court after the appeal had started. And we don't know the amount of the settlement. We have no idea what the amount of the settlement was. Both sides have kept it kind of quiet. So your guess is as good as mine. I think it was probably much higher than 791 and much lower than the 8,000. 10 years after the decision was made, Elizabeth Rutgers died, and the Waddington brothers continued to run a very successful business in New York. Hamilton actually represented them on a different case that had nothing to do with the anti-Lewis measures several years later. They had a linen store and a dry goods store, and they ended up developing a little bit of a business empire. And then Hamilton, this was Hamilton's first high-profile case, and his very first time delving into some of the issues that were to become a very big part of his career. So this case was the first time he really wrote briefs about things like the law of nations, about his belief in international legitimacy, and most importantly, about the concept of judicial review. The fact that he strongly believed that a court had the authority to hold pieces of a state legislation invalid or to interpret them in such a way that they would never be inconsistent with a federal treaty, or later with a federal statute, or later with the Constitution when it is ratified. And Hamilton maintained his legal career. He shortly after this he went to Washington for a while, or Philadelphia. And but when he comes back, he's settles into the New York bar, and it's an important part of his development, his relationship with the New York bar and the attorneys that he worked with. He took on a lot of pro bono cases, but he also really took on this Trespass Act because this ambiguous decision that the New York City Mayor's Court made in Rutgers versus Waddington really didn't clear up immediate issues, right? So the court did not strike down the Trespass Act. Instead, the Trespass Act remained, and Hamilton defended 45 other cases against the Trespass Act in the 3 years after Rutgers. Hamilton took on some of these cases pro bono, some of these cases he received his full fees for, but he fundamentally became one of the key people that almost every major Trespass Act case used as a defendant. And at the same time, his counterpart on the other side, John Lawrence, who was the other kind of young, new lawyer, took on almost every case on the other side. So Hamilton and Lawrence are just playing off of each other and having multiple court battles in different New York courts to determine what the future of this Trespass Act is going to be. Hamilton had several other notable cases. Another case that Hamilton did, Hilton versus the United States, was the first and only time that Hamilton ever argued before the Supreme Court. And it was another judicial review case where he thought again about these fundamental principles of federal supremacy in terms of and the ability of states to tax or to pass laws that were contrary to federal laws. He also argued shortly before his death, Hamilton argued the case of the People versus Croswell, which set the precedent for truth being a justification to libel, or a valid defense to libel. And in 1800, Hamilton was co-defense counsel with Broncos Livingston and with Aaron Burr in the first recorded murder trial in American history, which was the Manhattan Well mystery and the trial of Levi Weeks. So he had a long and flourishing legal career during the times when he was actually based in New York. So interestingly, even though there was 3 months of very intense fallout after that ambiguous court decision, shortly after Hamilton and Hamilton and Duane and Varick and everyone involved with the decision had faced all those public meetings and all those very, very aggressive anti-loyalist sentiment, the pendulum swung again, and people began to repeal the laws. So the state legislature started to repeal all the laws that between 1784 and 1788, all of the laws that were passed, all of these anti-loyalist measures were actually repealed. And about a year into the act, around 1785, people really stopped bringing prosecutions under these acts. And a big part of that reason is that the Tories, as Hamilton had predicted, kind of really became reintegrated into the economy and into New York society. They had made they were already a substantial part of it before the war, which is why New York had so much conflict, because people had these different political opinions, but there's large numbers of people on both sides of the issue. And so as relationships became more normalized and people began to do business with people who were on opposite political sides or opposite sides during the war, some of that resentment started to fade, and New York society and the New York economy got put back together again a little bit. And once these laws were repealed in 1788, the New York economy really started to stabilize. And Hamilton took on again the theory of judicial review that he had articulated here, and he articulated again twice in the Federalist Papers. And in two of the Federalist Papers specifically, Federalist 22 and Federalist 78. So in Federalist 22, Hamilton says, "The treaties of the United States under the present Constitution are liable to the infractions of 13 different legislatures, and as many different courts of final jurisdiction acting under the authority of those legislatures. The faith, the reputation, the peace of the whole Union are thus continually at the mercy of the prejudices, the passions, and the interests of every member of which it is composed. Is it possible that foreign nations can either respect or confide in such a government? Is it possible that the people of America will longer consent to trust their honor, their happiness, their safety on so precarious a foundation? So in Federalist 22, Hamilton is really, he's taking the example that he learned about the Trespass Act and thinking, if we really are in a position where the state legislatures and the state judicial systems are able to overturn or to have actions that are inconsistent with what the federal government does and with the treaties that the nation has signed with other countries, our peace is going to be at a very precarious foundation. And this was a really important concept to Hamilton. He articulated it again in Federalist 78. And this is kind of a more clear explanation of the concept of judicial review. He says, "The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents." So this, in Federalist 78, Hamilton really articulated in full force the theory of judicial review that would go on to become a very fundamental part of our legal principles today. The Supreme Court also articulated this view in the Marbury versus Madison case, when Justice Marshall essentially made this determination that when the Supreme Court is interpreting the Constitution, if there's a conflict between the Constitution and between the state laws or any law, the Constitution triumphs, and nothing inconsistent with the Constitution should be able to go forward. But the origins of that whole theory, and specifically the origins of Hamilton's beliefs on that theory, are kind of clear when you look at his arguments in Rutgers versus Waddington. So Rutgers had a major impact on everything that it touched, really. It had an impact on New York because the people of New York were permitted to, the people of New York had their entire state legislature challenged. And the people of New York this was a really important measure into New York's ultimate financial success because New York was essentially forced to integrate Tories and Patriots together. And New York had really been at a turning point. The anti-loyalist measures that were passed were designed with a very deep spirit of vindictiveness by people who had really suffered a lot under British occupation for years. And the fact that within 4 years by 1788, New York had really been integrated, and the people who had formerly supported the British were functioning members, respected members of New York society at the time, was very important because New York was really at a turning point where that didn't have to be the case. So it's true that thousands of people fled New York on Evacuation Day, and some people moved from, Tories moved from New York to Canada. But really, at the end of it, there was a bunch of people who stayed, partially because of the efforts of Hamilton. A substantial number of people stayed and really became integrated into New York society, which was very important for the future economic growth of New York and the nation. Hamilton also was really able to articulate his theory of equal treatment that he had expressed in the Phocion letters. It's not something that he articulated clearly in the briefs of the case, but it's really a huge reason why Hamilton went forward with so aggressively defending the rights of Tories against claims brought under the Trespass Act. Hamilton believed that if New York was able to target, if the New York State Legislature was able to target a specific group because of what it had done in the war, then it would be damaging for the entire state and for the rule of law in the area. And Hamilton also was able to really articulate that the Treaty of Paris, as the peace treaty, should be followed and should be respected. It's true that that was not always the case with the Treaty of Paris or with subsequent treaties, but it was a principle that a treaty that the federal government had entered into with another government was something that needed to be respected, and the state legislatures needed to respect it. It's also interesting, about 10 years after Rutgers versus Waddington, Hamilton wrote a letter to a cabinet paper, really, to Washington, where he talks about the impact of Rutgers. He talked a little bit about popular perception. He talked about how, because of how the statute was worded, everyone at the bar was essentially telling him that he did not have a defense, and there was no point in raising a defense. And he mentioned specifically that Thomas Jefferson had written that that it was not necessary for anyone to really consider these anti-loyalist measures because the court in Rutgers had struck it down as being inconsistent with the Treaty of Paris, which is interesting because that's not actually what happened. It was not struck down, but it's interesting because Jefferson, that's the only instance we have of Hamilton talking about Jefferson's understanding and use as a defense, because Jefferson did not want Washington to go into this analysis of all the states and all their possible anti-loyalist measures. So Jefferson was saying, hey, we have this example in New York, we had this law that was passed, the courts took care of it. So it's kind of an interesting statement. So 10 years later, Hamilton and Washington are looking at the Trespass Act again, and they're looking at it through the lens of relationships with the British government. And Washington officially sent letters and sent instructions to the state legislatures to not pass punitive laws that were specifically targeting these Tory groups. So the case is important really for three reasons. So one, the principles of judicial review. Two, the New York economy and the New York, just the attitude of the successful victors, of the patriot victors, to the people that they defeated in the war, their former neighbors, former business associates, because there was an open question of really what could have happened at this time. And three, I think it's important and interesting as a way that we look at how early international law was practiced in American courts. The fact that the law of nations and what Hamilton learned and cited in Grotius and in Vattel was a fundamental part of his briefs. It's cited on almost every page of some of his briefs. Three of the briefs actually focus on international law issues. And he thought that the justification and the laws of nations and the rules of war were something that a New York City mayor's court needed to be bound by. And the court itself, in its analysis, also went really into a deep analysis of Grotius and of Vattel in order to determine that some of Waddington's conduct and some of what he did during the war he should not be penalized for. So that is my presentation. I want to thank the Museum of American Finance and the Alexander Hamilton Awareness Society. Thank you for listening.
Many people don't know this, but Pooja has been taking leaves of absence and digging into many of the Hamilton legal cases because there really isn't a definitive or a good book describing a lot of these cases. So we've been blessed to have many of her presentations, but she says it's okay for the first time to feel comfortable sharing what her plans are to move forward with her research into next steps. And so I thought it would be nice for you to share the progress and ideas that you have.
So I've been really focused on Hamilton's legal cases. There's been one 5-volume set published by Julius Goebel in 1970s at Columbia that really gathers a lot of Hamilton's materials and his briefs and his practice manual and a lot of the important legal papers. But there hasn't really been a book or a project that focuses on the stories of these cases, which I think is something that gets lost. Like in this case, for example, with Rutgers and Waddington, you have really multiple people involved. It's not just the legal issues that were determined. It's the fact that on one side you have a sympathetic patriot widow, on the other side you have these like allegedly scheming British merchants, and then you have the role of the popular press, of public outcry, of the people that are sitting around crowding the courtroom. So I've picked a group of 8 cases, and I've been kind of delving into them, researching them, reading the newspaper articles, and then combining that with a legal analysis of the actual materials. And I'm planning to finish it this year, but we'll see how that goes. And trying to write a series of shorter articles. And I'll be updating my blog, which is www.itshamilton.com, with kind of these issues. The next series I'm planning to do is a series on Hamilton as an international lawyer. So essentially we'll go into Hamilton's use of Grotius and Vitella and how he believed that international law played an important role in how he argued his cases.
Well, thank you,
Thanks.
Pooja. Thanks to Pooja, we had an insight into Alexander Hamilton's leadership on the legal side. With the exhibit, John Herzog, we got to hear about the financial beginnings and how it shaped in the early years. We had the Coast Guard here, which showed Hamilton's approach to protecting our shores so we got revenue to run the government. So legal, financial, military, how society is trying to do is to bring together the people of all these various talents to help raise the understanding of the breadth of contribution of this great gentleman. And if you'd like to support the mission, because as everyone knows, to keep going, we have to get funding. So however you can support the ability to bring the talented people here, we appreciate it. So thank you very much. Thank you very much for coming. Thank you, Museum.